Welcome to the Generis Show, your unique perspective on everything you need to know about your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. Today in segment one, we'll be discussing the acquittal of a grieving father who was accused of threatening a judge, the release of an unjustly convicted sex trafficking victim, and my recent visit to George Floyd Square in Minneapolis, Minnesota. During segment two, as promised, we'll be exploring the seriousness factors considered by a sentencing court under revised code 292912 in the state of Ohio. To make sure you don't miss an episode, subscribe on Apple Podcasts, Spotify, and YouTube. Look to the law office of brianjones.com and all of our social media outlets for everything you need to know about your civil rights and the criminal injustice system. So, Erica, did you see in the news this week the story of the grieving father who blamed a judge for his son's death on Facebook and then got jailed and tried for making threats against that judge? And he was ultimately acquitted just this week.
Wow, what an amazing story. Your heart has to go out to the father. I guess you could have handled things a little differently, like we all can from time to time. But can you just catch us up on how the father came to be charged?
So Jonathan Vanderhagen's toddler son, Killian, died of hydrocephalus, which is a brain hemorrhage, just days after he had filed for custody of his son, emergency custody of his son. Now, Vanderhagen alleged that his son's mother had missed multiple critical doctor's appointments for the child. And obviously he was right in that allegation. Vanderhagen targeted the judge who refused to give him custody, who was overseeing the case after the child's death, posting pointed Facebook posts and including pictures, screenshots from the judge's personal Facebook account. And because of that, Vanderhagen was charged with misdemeanor malicious use of a telecommunications device, but he was ultimately acquitted after a jury trial. He had to sit in jail for the entirety of his case because he couldn't afford to post bond.
Wow, this is just heartbreaking. Can a judge be an alleged victim and testify at trial?
Oh, absolutely. Judges can be both victims and the perpetrators of crimes, as we have seen right here in Marion, Ohio. In some regards, judges are honestly held to an even higher standard than the average attorney because the ethics of being a judge should be more highly scrutinized. So when a judge testifies against somebody that comes before him or her in court, I think they have a unique ethical and legal obligation to be exceptionally candid. Now, regardless of the outcome of this case, I think this judge's image of being an impartial and unbiased jurist has been affected to his detriment, and the publicity surrounding this case and the ultimate acquittal of Mr. Vanderhagen is going to damage this judge moving forward.
Oh, no doubt about that. I mean, you would think that a judge would hold himself to a higher standard. And I am so glad, and we have talked about it over and over again on these shows about how judges and attorneys are held to a higher standard, and they even police each other to some extent. I thought that the First Amendment would protect anyone from saying what they want, posting what they want, writing what they want in the newspaper. I mean, it seems like maybe there could have been some protection there. And why didn't the First Amendment prevent him from being criminally charged?
Well, first and maybe most importantly, the First Amendment isn't a complete blanket protection. Things like threatening statements are not protected under the First Amendment. Now, whether a particular statement is or is not a threat is really a question of fact for a jury to decide based on totality of the circumstances, everything that's going on in this situation. Now, in this particular case, sharing personal photos, calling out the judge personally, verbally attacking him. Not that there were any specific threats made, but just being really targeted and blaming the judge was by law enforcement interpreted as threatening behavior. I think it could also be viewed as possibly stalking behavior or harassment if Mr. Vanderhagen is repeatedly tagging the judge, posting repeatedly on his page. Now, there's no evidence that any of those things happen. I'm just trying to give some examples of how what many people think as normal social media behavior and legal social media behavior can cross the line into criminal conduct. Now, in this particular case, the target was a public figure, a judge. So that speech also has an extra layer of kind of First Amendment protections as political speech, because judges are elected, and therefore, Mr. Vanderhagen can attack that elected official on a policy basis and on a performance basis. So I think while we don't know the exact details of Mr. Vanderhagen's defense, and in these sorts of cases, we never know exactly what went on at trial, short of reading the entire transcript. I think what we see here is, obviously an aggrieved father who wanted to put out into the world his anguish and targeted this judge, saw the judge as the cause of his anguish, and according to the jury, validly went about voicing his grievances.
Well, I guess the lesson here is to always think before you speak and share photos and attack somebody. I mean, nobody should be bullied. We have the legal system to make sure that these matters are taken care of appropriately.
You're absolutely right on that point, Erica. And Mr. Vanderhagen has spent a significant time in jail. He may ultimately have been acquitted of this allegation, but he's lost a significant portion of his life. I'm sure that he's out, substantial sums of money. So it did not come without consequences. And speaking of consequences, Erica, did you see in the news this week, Alexis Martin, who has been suffering consequences for decades, has now been released from the Ohio Reformatory for Women on supervised release? Alexis Martin being the victim of sex trafficking and then the victim of the criminal injustice system.
How did Miss Martin come to be criminally charged? I mean, it sounds like she had a really tough life before this charge happened.
Yeah, so she was being sex trafficked at the time that this incident happened. This incident landed her in prison at the age of 15 years old. What she did in order to get herself out of that situation was she coordinated the robbery and ultimately murder of her alleged pimp, which resulted in her conviction and the conviction of several other people for that shooting. Ms. Martin was painted by the Summit County prosecuting attorneys as a callous and calculated criminal. And she was shown no mercy by the Summit County prosecuting attorney. They knew full well her situation as a victim, a child victim of rape, a child victim of sex trafficking, and they turned a blind eye to it. The Summit County prosecutor's office under Sherry Bevan Walsh was one that would never shy away from a microphone and a media appearance. And they saw this particular case as an opportunity to present themselves and campaign on a very public stage. And they exploited, once again, Miss Martin for their own political gain.
I mean, my heart goes out to her. I mean, what happened was terrible, but we talk about this all the time on the show, how people need help to recover. And in this case, I mean, she was a victim of something that a lot of people don't come back from. And I can't even imagine how she survived such an ordeal, but she should have absolutely been given some empathy during the trial. Now, can you tell us a little more about the safe harbor law and how did they miss this in her case?
Well, I think it was an intentional desire to turn a blind eye to it on behalf of the prosecutors. I think they made the affirmative decision to ignore this provision of the Ohio Revised Code. And I think combined with poor defense lawyering is what landed Ms. Martin in prison for as long as she did. Ohio law provides that if you are the victim of sex trafficking and sex crimes, your case can be put on pause while you receive therapy, a guardian ad litem is appointed to you, you get drug treatment, so that you can go into being a victim of sex trafficking does not in and of itself excuse all of your crimes, but it does provide substantial mitigation at the time of sentencing. And even an offense, for what Ms. Martin was ultimately convicted of has the possibility of being amended, reduced to a level, she was charged with murder. You can amend that, you can reduce that to a crime like manslaughter, where the possibility of probation now comes into play. And because of all of the mitigating factors, this is exactly what the safe harbor provision is designed to encourage prosecutors to do. And it's exactly what a defense counsel is supposed to raise during the discussions of these sorts of situations. And in this case, the Summit County Prosecutor's Office absolutely failed Alexis Martin. They failed to apply the safe harbor provision to her case. They failed to get her treatment. They failed to protect a 15-year-old child from being raped repeatedly at the hands of a relative. And instead, they used her for their own personal gain and imposed the most severe conviction they could possibly obtain, despite her history of trauma and suffering. Now, fortunately, she has been released from prison, but she's still on parole. They won't roll back and undo the horrible things that they've done to her. And she's going to continue to be monitored by the government under conditions, and she's not truly free of the intrusion of the government in her life, the same government that refused to protect her when she was a child sex trafficking victim.
Brian, I really wish you had been her attorney because it makes me want to cry, like listening to all of the ways the case went wrong. And it's a really good testament to having an attorney that knows what they're doing. And it's kind of interesting because I do attorney interviews, and the other day I did one and I said, hey, there are bad attorneys. And the other attorney was like, oh, we don't want to say that online. And like, I don't want it out there that I said there are bad attorneys. There are bad attorneys out there that not everybody knows what they're doing. Not everybody has the right strategy. I mean, everyone has the same tools, but it's how you put it together and protect your client that really matters, and it makes a difference in their lives. And it's not just about winning or losing a case. It's what happens to these people and their families forever after something like this happens, and they need a great attorney to help look at all the different strategies and pick the best one. So I'll let you answer this question. Why is it important that her trial defense attorney is cooperating with her appellate efforts?
So under the controlling case law for establishing ineffective assistance of counsel, a key element of making and succeeding in that claim is establishing that the work that the defense attorney did was below the standard of competence accepted as a defense attorney. In this case, if the defense attorney is being accused of ineffective assistance of counsel, is cooperative with the subsequent attorneys, the attorneys that are now alleging ineffectiveness, saying, your trial attorney wasn't good enough, didn't meet the minimum standards for competence in defending you. If that trial attorney says, yeah, I made a mistake, I screwed up, I wasn't good enough here, it makes it easier to create the record to support that legal claim for rolling back the conviction. Honestly, it's a mark of integrity that a defense attorney would admit to making that mistake. And I've been on the case where the prior defense attorney refused to make that admission. And I've been in situations where the prior defense attorney came in and said, yeah, I didn't understand the law. I made a mistake. I overlooked something. And, the reality is lawyers are humans. I know many people out there in our listening audience think that we are hatched from underneath a mossy covered rock. But the reality is that we are born, we are human beings, and we make mistakes. And in this situation, the fact that this defense attorney was willing to come forward and admit the mistakes that were made at the trial level is going to help Alexis in her battle for exoneration.
Wow, that is not what I thought you were going to say. Hatched from under a mossy, what did you say? Stone?
Yeah, we actually don't crawl out from under rocks. We're born, we have mothers and fathers.
Oh, I mean, I actually was going to be a lot nicer. And I thought you were going to say hatched from a golden egg, because I I think that attorneys are incredibly valuable, especially when you need them. But I mean, I get it. There's a lot of lawyer jokes out there, and I know that some lawyers deserve that. But all the attorneys I know are really good people, and I've been lucky to get to know them personally. And yeah, they are human beings. And I do love the integrity that is shown when people can admit a mistake. It's really important in life, not only as an attorney.
Absolutely. Absolutely. That coming forward, admitting your mistake, I think is not only a sign of integrity, but a sign of uh, personal reflection and comfort, because we all do make mistakes. And being able to admit when you've done that is a huge indicator of maturity and personal growth. A moment of personal growth for me, and everybody may realize that we were off last week because I went on a trip to Minneapolis, Minnesota, and as part of that trip, visited George Floyd Square in Minneapolis. And I wanted to take a few minutes today to discuss that experience, especially with the sentencing of Derek Chauvin coming up on June 25th here in just a week.
Well, I didn't know you went away. I know that we didn't get to do our podcast, but I'm super interested to hear what you learned when you went there and what you saw. What a great experience that must have been.
It was a moving experience, Erica, and I think when you first come into the reclaimed area, the volume of art and the messaging of the art really is the first thing that hits you. As the direction that we came from, there was names written they were about a foot tall each, that covered an entire city block. Names of people who have been murdered by police. And walking in and seeing that massive list of names was powerful. It was moving. And then the Black Power fists that jut up from the square, the square that's in the middle of the intersection, is the next significant item that really grabs your attention. And then as you're walking around the area, you see all of the art and the messaging that it brings to the experience is just, it's moving. It's powerful.
Yeah, art is so powerful. And I mean, I know that it's been used in protests in the past. And I mean, can you think of any other examples of where this you really have seen art in protest?
Well, I think, we look back to the most iconic images of the civil rights movement, of the women's suffrage movement, any major political movement across the world, and you see the protest signs, you see the banners, you see the art coming through in a variety of ways. And I think the impact of art in this particular setting, as a memorial, as a message, was quite effective. At least for me, that message of anguish came through in what you see in that area. But it's coupled with all of these gardens, the the plants that are being grown there, the flowers, as and that's interesting because it sends this message of rebirth, of bringing this neighborhood back into the fold. Remember that the area that George Floyd was murdered in, is an underserved neighborhood. It's a neighborhood that that every city across the nation has in their city and has discarded. That's the neighborhood that you don't go into. Um, and the fact that people would come into this space and try to give it an opportunity for rebirth, I think serves two purposes. One is the messaging that we have at any site of somebody's death or their internment, of the growth that we put flowers on a grave for, but also as a way of taking over this space. One of the things that I thought was really interesting was the demands of the protesters are written on huge pieces of plywood. I mean, they had to have been 15, maybe even 20 feet tall, and letters written, 6 inches tall, of all of their demands. And the message of the occupation is, you can't forget about us. We are not going to allow capitalism to continue in this space. We are not going to allow the machinery of money to continue using this space until you address what's wrong with the way that you're using us as a people, treating us as honestly, cattle at this point. And there's this tension that can be experienced, especially today. We talked to some of the people that were still occupying the space, and in the days and weeks after George Floyd's murder, that space for a 4-city block radius was completely shut down. And the city then sent in law enforcement and trampled all of the art, and trampled all the installations, and trampled all of the memorials, and just swept it all out. And they took it back. And then the city came in and they said, no, you've got to let people come through here. And there's a real tension even among the occupiers of, how much are we, there was limited traffic that was going through the area, but it was slowed down. It was kind of monitored as it came through the area. It was very obvious that some of the occupiers weren't pleased about that, but some of them were, starting to acquiesce, because there's this tension of, have enough of the demands been met to allow some concessions, and seeing that process work through was
Well,
really.
Yeah, I mean, that sounds incredibly interesting. So I wonder how that works as far as like reopening up that area to traffic again, and allowing the city to use that space again. I mean, are they going to be taking away the art installation in the gardens?
Yeah, so as of the time that I was there were still concrete barriers, protecting the location, the exact spot of George Floyd's murder. Um, the locally owned shops were reopened. There's a little bodega there. a barbecue place, and then a community center. It wasn't really clear exactly what one of those buildings were, but what it appeared to me was that the locally owned shops were reopening, and they were being used. The Speedway, from which George Floyd had purchased the cigarettes, has been completely shut down. That is completely occupied. The name Speedway has been ripped off of the building and replaced with signage that says the People's Way. And that whole building has been turned into almost a memorial and a base camp for the occupiers. Which is interesting, because a lot of the debate over the last year has been about the appropriateness of destruction of property as a form of social and economic protest. And it made it very apparent to see what they had done with the space as to why that form of protest is important and valuable and justified to me. Reason being is that these people have been crying out for help. These neighborhoods have been crying out for help for decades, and nobody listened to them. Nothing changed. But when you see Minneapolis burn, when you see Portland burn, when you see Seattle burn, and then months later, we now have reform movements in Virginia. We have reform movements in Philadelphia, reform movements that we have talked about on this show, reform here in Columbus, Ohio, reform in Minneapolis, reform in Portland. You start to understand that they are not going away. Their demands will be met, or they are not going to participate in the social contract anymore. Because that's the agreement that we have all made. Back thousands of years ago, life was nasty, it was brutish, it was short, and we all had absolute freedom to do whatever we wanted to do. But we all agreed to give up some of that freedom to form this social contract that we're all going to work together, and we're going to live by a code, we're going to live by rules, and we're going to comply with each other. And the occupiers feel that that contract has been broken, and so they're not going to abide by it either. Just like if your cell phone stops making phone calls, are you going to pay that cell phone bill next month? If your cell phone company says, man, we're just, you're not getting internet anymore, you don't pay that cell phone bill. That contract is broken. And from their perspective, and I got to tell you, their demands make sense. That social contract has been broken, and so they're not going to abide by it anymore. And so what comes next? How do we renew that contract? How do we rewrite the future? And that, Erica, is, in my opinion, the most exciting thing that is going to happen in the coming months and years.
I mean, that is exciting. It is too bad that those points have to be made where businesses can be destroyed in the process, because that kind of hurts themselves a little bit. But I mean, as you pointed out, it wasn't until cities started burning that change started to happen. And I think that the end result is great. And it's unfortunate that extremes have to be made. It's not the way to say it. It's unfortunate that people have to go to extremes in order to have just basic human rights be protected.
I think that's exactly right, Erica. Yeah. Well, let's move on to segment 2, our featured topic this week. Ohio courts, like the federal system, have discretion in issuing sentences to convicted defendants. But that discretion is guided by what we call the purposes and principles of sentencing. And in the context of felony convictions, the purposes and principles of sentencing is further guided by the seriousness and recidivism factors. Today, let's explore those seriousness factors as it applies to Ohio sentencing laws.
Wow, I mean, this sounds like how I punish my child. We have a seriousness factor involved, and same thing with rewards. There's stickers and prizes, but I'm sure that that is not what they use at the court system. So, if you could give us some insight as to what are the seriousness factors under RC 2929.12B.
Yeah, so I commend you for considering in your parenting, Erica, because it harkens back to a time before there were sentencing factors in Ohio law or in sentencing law across the nation. Because there was a time when judges had complete discretion. The legislature said 1 to 25 years. And the judge just said, well, the number is 18, and didn't really have any guidance as to how we reach 18 or how we reach 1 or how we reach 25. Ohio has applied some of that guidance. And this is in large part reactionary to sentencing guidelines that were placed on federal judges. It's important to understand contextually that these sentencing factors consider essentially 3 levels of each offense: a less serious version, the regular old, this is the crime, and a more serious version. And how do judges decide among the various degrees of consequences where to put a particular action? The seriousness factors address the factual circumstances that lead a crime to be considered more or less serious. Now, there are 9 more serious factors listed in the revised code. And the first of those factors is the injury suffered by the victim was greater because of that victim's physical condition or age or mental condition. The second factor, again, is victim oriented, and it's, did this victim suffer extreme physical, psychological, or economic injury? Did they get really, really hurt? Or did they lose a whole lot of money? Was the offender, the third factor is, was the offender holding a position of trust or a public office at the time that the offense was committed? Was the offender's occupation or profession putting them in a position where they were supposed to prevent that sort of offense from happening? Was the offender's reputation, occupation, or position used to make the offense occur, to facilitate the offense in some way? Did the offender take advantage of a special relationship with the victim? Did the offender commit the offense as part of an organized criminal activity or for hire? Did the offender have a race or ethnic, gender, sexual orientation reason for committing the offense, that kind of hate crime enhancement? And was the offense committed in front of a child? Are the more serious factors here.
Yeah, and I can think of a lot of the cases that we've spoken about on this podcast as more serious because of some of those situations. What if they say, oh, well, my sister made me do it and gave me the idea? I mean, so is it less serious? Like, it wouldn't have happened if somebody else wasn't involved? I mean, are there cases where there's a way that the charge would be less serious because of how it happened?
Well, absolutely. And I think to kind of use your child analogy here, the victim, and so there's four factors that make a crime less serious than the average version of it. And the first is the victim induced or facilitated the offense. So, yes, I saw you smack your sister, and your child says, well, she hit me first. Well, so the victim induced or encouraged the offense to happen. the offender acted under a strong provocation, or there was something that caused the offender to do this. In committing the offense, the offender didn't expect to cause physical harm to anybody. Or other, there's kind of a catch-all, substantial grounds to mitigate the conduct, even though they don't constitute a complete defense to the crime. So, anything out there that would limit the offender's responsibility can reduce that. So you think of a few situations, the security guard that shoplifts is substantially more serious crime than the starving father who steals a loaf of bread for his children. The police officer that uses his badge and cruiser and uniform to gain an advantage over a young woman and sexually assault her is substantially more dangerous than the boyfriend who just one night won't take no for an answer. The predatory nature of the police officer, as opposed to the position of ignorance, albeit criminal ignorance, that the boyfriend takes, makes one version of sexual assault worse than the other. So these are really guiding factors so that judges can objectively, rather than on a race base, oh, you're a black man, you're going to prison forever. We can have objective measurements of a particular version of an offense. And this is something that's really critical when we're talking about this particular area of law, is that murder isn't compared to shoplifting. We compare murder to murder. We compare rape to rape. We compare theft to theft. And is this theft more or less serious than the average theft?
I mean, that makes a lot of sense. You want to compare apples to apples, and it's it seems like the best way, and that way it protects the judges and the attorneys from wrongdoing, because they can point out different examples of how other cases were decided and what the punishments were for those other cases. And I mean, and that's why they quote case law, isn't it?
Yeah, that's precisely correct.
All right. Well, I mean, so maybe you can give us a little more detail on how these factors are applied to the benefit of of a defendant.
Yeah, so we write sentencing memorandums in the vast majority of our felony cases, and occasionally in our misdemeanor sentencing cases, where where there's are we going straight to probation, or maybe somebody's getting jail time, or maybe somebody's getting enhanced jail time. We like to use sentencing memorandums and make those written arguments to the court so that we have documented the reasons why this particular offense is less serious than the average version of the offense. And a legal argument can be made to the benefit of a convicted defendant by arguing for the exclusion of more serious factors and the inclusion of less serious factors. In circumstances where a pre-sentencing investigation report is issued, the defense attorney has to rebut that assessment, that probation officer's assessment, which is going to be skewed towards finding the more serious factors and painting this particular offense as more serious than maybe what it really is, because they take such a law enforcement oriented view of these situations. So yeah, these factors can be applied properly, with proper analysis and understanding of your case, to the benefit of the accused or now convicted defendant.
And that makes a lot of sense. And you need a great attorney to understand how to use that to their benefit. And so your clients are very lucky. I would strongly suggest that anybody that has questions on a criminal matter for themselves or for someone they know, to absolutely give your office a call, because not only do you know what you're doing and you've been doing it for so many years, but you really care, and you care about the changes that are happening in the law enough to keep learning, and even incorporate those on your family vacation. So, and I loved hearing about that today. And I also just want to say one quick thing. I want to congratulate you. It's the 50th episode of the Sui Generis show, and it's been amazing to be a part of it. And I think that the audience, people that get to see this show, hear this show, um, keep updated on the information and the criminal and justice system, and watch the changes happen. I mean, you do a lot of research on this, and we appreciate it.
Well, Erica, thank you so much. And how exciting that we've now reached 50 episodes of the Sui Generis show. Um, People, I think everybody universally bags on the pandemic and what a terrible thing it was. But I think with a little bit of distance and some reflection, we'll see things like this show. I read stories all the time of people that have left their desk jobs and gone out and started landscaping businesses, and just really changed their lives because the pandemic made them do it. So while right now it's very painful and we all hate 2020, when we get to 2025 and 2030, we may look back at 2020 and say, gosh, that wasn't, that may have been the turning point of the world. When we look at how global climate change has come to the forefront, how civil rights issues have come to the forefront. And does any of that happen without coronavirus? And I don't know that it does. But thank you, Eric. I appreciate you joining me, and everybody who's been on this wonderful, wild ride for now 50 episodes. I appreciate you listening in, and to stay informed about the most interesting stories in the criminal injustice system, police and government accountability, sentencing laws, and everything that you need to know about your constitutional and civil rights, check out the law office of brianjones.com, facebook.com/Central Ohio Criminal Defense, and at TLOBJ on Twitter, Instagram, and TikTok. We'll be back next week with a sui generis perspective on the next big stories in civil rights and the criminal injustice system, as well as segment 2 featuring our discussion of the other factor in sentencing laws in Ohio, the recidivism factors. Erica, my grandfather always told me when we parted ways, don't do anything I wouldn't do. And to that, when I part ways with my friends, I add, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.